This slide is the continuation of the Sale of Goods Act. So in the previous classes we have discussed how a sale of goods can be taken place and how a property is transferred or the proprietary rights of the property is transferred from seller to the buyer. In this now we are going to study when a title is said to be passed. So once a proprietorship is transferred, the property is transferred said to be taken place. Somehow how a title is said to be passed. When the possession is taken by the buyer, sale takes place or by the proprietary right. So for that we have to see person who is taking the property, risk passes with the property. So in every sale of goods, taking property is essential and no one can give a better title than he himself has. That means if any person or any seller who is a original seller or original owner of the property, he can only pass us a better title. If the person himself is having no title over the property, he cannot pass a better title to the buyer. But there are certain exceptions for the saying that is a nemo dat quod non habet. Nemo dat quod non habet means only a person can give a better title than himself possesses. That means if the seller is having a possessory right over the property, he can pass a better title. But there are certain exceptions wherein even though the possessor of a goods having no title over the property but passes a better title. For that, first one exception is sale by a mercantile agent. Who is a mercantile agent? We have seen selling, buying and raising security on the goods. He is called as a sale of a mercantile agent. So always mercantile agent is having a possession of some property or goods which belongs to the owner. So the mercantile agent, though not the owner of the property, can pass a better title the property to the buyer. He can also pass or he can sell or buy, can pledge the goods, and he can while doing in the ordinary course of business, he can pass a better title having possession of the goods or document, sell them to a bona fide purchaser. So any sale or any pledge, anything, sale of document or transfer of goods or document can be made possible by a mercantile agent as if it were done by seller himself. Then by sale of joint owner. If there are two more owners for a particular property or a particular good, any sale made by any one of the joint owner can also holds other owners. Similarly, sale by a person in possession of a voidable contract. Voidable contract means a property can be declared as void or not declared, it become a valid contract. So any one person is having any property under a voidable contract, he can sell those property. And sale by estoppel. If the owner of the goods by the act of himself or creates an impression in the buyer that the seller has the right to sell. That means being an agent of the owner makes an impression to the third party that the seller is going to sell on behalf of the owner. In such cases, it is sale by estoppel, though he is not the owner. Then sale by a person in possession after sale. Sometimes proprietary right was passed, but possession was still in the hands of a seller, and the buyer has not paid the money, or the buyer has misconducted something or act done in violence of the contract of sale. In such cases, possession was still in the hands of a seller. Sometimes, in some cases, seller can resell those property by not being a owner of that property. And lastly, sale by an unpaid seller. Unpaid seller means the person whose amount is not fully paid up by the buyer, he is called as an unpaid seller. So unpaid seller has a right of lien and a right of stoppage in transit. Sometimes he can sell the goods also. And then once all the contract has been made between the seller and the buyer, then performance of the contract by delivering the goods. If the seller agreed to sell or agreed to sell to transfer the property, then delivery of the goods was the foremost essential part. So the duty of the seller is to deliver the goods and buyer duty is to accept the goods and pay for the goods. So delivery means actual handover of the possession of the goods. So delivery of goods may be made by doing anything. That may be, we already discussed in the last class, symbolic delivery, constructive delivery, actual delivery. Delivery of goods can be made possible. And also place of delivery. Normally buyer has to apply to the seller where the delivery has to be taken place. So it is a duty of the buyer to apply for the delivery, then or else it depends on the intention of both the parties. If the seller says one place, buyer says one place, they will come to an agreement to where to take the delivery or to where to sell the goods. Then rules of delivery, the parties can make some of the conditions or the terms in their agreement. One is a time of delivery. Suppose if the time is an essential part of the delivery, then seller has to sell that goods within that time, or time has not been a part of their contract, but there is always a presumption that anything which be contract must be completed within a reasonable time. So what is a reasonable time depends on circumstances of each case. Hence delivery must be made if the time is mentioned within the time or else within a reasonable time. Delivery by allotment. Normally if it is a one transaction, possession in one bulk, delivery must be given, or else if the parties agreed for the allotment of delivery by installments, then delivery, part delivery can also be, by allotment can also be made. So sometimes effect of part delivery. So some portion of goods has been delivered, some was still in the possession of the seller, but sometimes part delivery presumed to be the delivery of the whole of the goods. If the goods can be severable, then allotment of delivery is made possible. If the goods cannot be made separated, then whole goods must be delivered at once. Then buyer must apply for delivery. Suppose if the delivery of wrong quantity, instead of what they have been contracted for, less quantity has been delivered or more quantity has delivered, buyer can accept or he can reject the contract. Then installment delivery. Suppose if the buyer has not made any intention or not shown any intention to accept the goods in installment, then buyer can refuse to accept the installment delivery. Sometimes if the seller and the buyer are in far off places, in such cases delivery must taken place through a carrier. So delivery, once a seller puts the goods in a delivery or in transit, then risk passes or proprietary rights transfers to the seller to the buyer. Suppose in case of sea routes, suppose if the delivery is taken through routes in ships or in cargoes, in such cases, such contracts, property in goods passes to the buyer after it has been loaded on board the ship. When the goods have been boarded on the ship or put in the cargo, that proprietary ship or a property passes to the buyer, and the seller or the shipper bear all the expenses. Up to the shipment, it is at seller's risk, all the expenses borne by either by the shipper or by the seller. Risk passes to the buyer on shipment of the goods. And all insurance and freight charges to be included in the price, because it is always necessary while going on seaboard. So insurance must also be included in the cost of the goods. Then in ex-ship contracts, delivery of goods at port of destination. That means when the goods have been delivered to the actual port, then proprietorship is said to be transferred. Then acceptance. So when the seller sells the goods, it is a duty of the buyer to accept the goods. So when acceptance is said to be takes place, when a buyer intimates the seller that he has accepted the goods, then possession or the transfer is said to be takes place. Or if the buyer does any act which is inconsistent with the ownership of the seller, in such cases it is deemed to be delivered to the buyer. Or if the buyer retains the goods beyond reasonable time without returning the goods or without informing the seller, in such cases it is deemed to be the buyer has accepted the goods. So in some cases, if the buyer has not taken the goods or accepted the goods beyond reasonable time, or he has not taken the delivery beyond the reasonable time, and then it is a duty of the seller to ask the any loss or reasonable charges for a care and custody. Suppose if the buyer has accepted the goods but has not taken the delivery, in such cases buyer has to keep the goods in his custody. So whatever the cost that has been incurred for retaining of the goods, that amount can be reimbursed from the buyer. Then unpaid seller. Unpaid seller is a person whose payment for the goods has not been fully delivered. So he can exercise some of the rights. Unpaid seller, he has been immediate right of action. Suppose upon delivery of the goods, the buyer has to pay for the goods. If the payment has not been made, then the seller will given all the rights, can exercise all the rights against the buyer. So any negotiable instrument given got dishonored. If the check is dishonored, bill of exchange is dishonored, then also is considered to be a unpaid seller. Not only money, some of the documents also, if dishonored, check is dishonored, then it is considered to be a of unpaid seller. There are certain rights of the unpaid seller against the buyer. So first thing is the right of lien. Right of lien means the seller can withhold the goods in his possession until the payment is fully paid, or sold goods without stipulation as to credit, or sold on credit but terms of the credit has expired. That means if the buyer has accepted the goods but has not paid the money, and also he has accepted the terms of the contract but amount not paid, or the buyer becomes insolvent before making the payment, in such cases that unpaid seller can keep those goods in his possession until payment is completed. Suppose if the goods have been put in transport, in such cases he cannot, that possession was already beyond the possession of the seller. In such cases he can stop those goods in the transit. Transit means he can ask the transporter not to deliver those goods to the buyer. In such cases, those goods which is in the transit is deemed to be in the possession of the seller. And lastly, right to resell. Suppose if the goods are in the possession of the seller and the amount cost of the goods has not been paid to the seller, he can resell the goods. And other rights against the buyer, he can sue for price, sue for damages, and then repudiation of the contract before due date, or sue for interest, because these are all the rights which an unpaid seller is having. In addition to that right, because that seller or the buyer has not taken the goods, so much of damage or so much of loss, so much of loss of sentiment also is caused to the seller. In such cases, all these rights includes other rights against the buyer also. He can resell and ask for the damages, or he can file a suit for cancelling the contract, or whatever the amount has been remain unpaid, he can claim interest also. And then when a termination of lien is said to be, suppose if the unpaid seller creates a lien on particular goods, then if the seller delivers the goods to the carrier without preserving the right of disposal, that means that goods has been already delivered to the carrier and the rights of the seller has been disposed of. In such cases, he cannot claim a right of lien over that. And then by waiver, if the seller himself waives the right not to have a right of lien, in such cases, he himself has cancelled it. Then buyer lawfully obtains possession. If already before claiming the right of lien, if the buyer already obtains possession of the goods, then the seller cannot exercise this right of lien. Then the only thing is, it is a remedies for breach of contract against the seller and suit for price, damages for non-acceptance. Even if the seller has not incurred any loss, but contract has been entered into between the seller and the buyer, and then such cases the seller can ask for not accepting the goods and also go along with the price and the damage. And then seller's remedies against the buyer. Seller remedies, suit for price, damages for non-acceptance. Buyer's remedies, damages for non-delivery. If the seller has not delivered the goods, even after payment, in such cases, buyer can ask for the delivery of the goods. Suppose if not delivered, he can apply for the breach of warranty and for specific performance. Specific performance means actual performance of the contract. The buyer can ask for that also. That's all with respect to sale of goods.